The very first criminal jury trial I presided over as a judge involved a shooting case, and the victim had been paralyzed. And I call him a victim now because the defendant was found guilty, and that's another video for another day. But the word victim has no place in a criminal jury trial, and you need to motion and limine that out because it shifts the burden back on the defendant to prove that the victim's not a victim. If it's a self-defense case, there's no victim. If your defense is that it never happened at all, there's no victim. There's only a victim in those cases when the jury finds beyond a reasonable doubt. So back to my point, this guy was shot and paralyzed, and the defendant in this case was claiming self-defense. And it was a real tenuous case. But what I noticed about this lawyer, he was new to me. He was a new lawyer. I'd never met him before, never heard of him. And he was one of the nicest guys. He comes in this courtroom and he starts talking to the jurors, and he's so laid back. And he didn't have the same training I did, but he had the same philosophy about trying a jury trial to represent your client. He was just as nice as pie to the jurors. He was relatively nice to the witnesses. What I noticed about him is that in voir dire, he started sneaking in the word "we" with the jurors. It was very subtle. It's very subtle at first. And at times in his cross-examination of the state's witnesses, he would sneak in occasionally, just very occasionally, well, but we'd like to know, and he would look at the jury and say, we'd like to know the answer to this question, or we'd like to know what it is you saw. So can you tell the jury what it is that you saw? And he started sneaking in the concept of "we" with this jury. The "we" being him and the jury. That was "we" to him. But it was very subtle at first. And I noticed a little bit, and it was not offensive. It wasn't intrusive. It didn't invade the purview of the jury. It was very subtle. And it was so subtle there were never any objections. In his closing argument, he used the word "we," and he would motion like this to the jury. We would expect this, and we would expect that. And we shouldn't believe that this happened and that happened. What we want to see from the state, and for they prove their case, are these things. And so he incorporated "we" to the jury and the hand gesture of "we," and he was nice enough, and he was polite enough, and he was credible enough, and he was able to lend credibility to his case because he had credibility. Before he walked in the courtroom, I since got to know him, and he is a very credible lawyer. He had credibility when he was home. He had credibility when he drove to work. He had credibility when he came to the courthouse. He had credibility when he walked through the door, and he had credibility throughout the jury trial. And in the closing arguments, he was able to get by with using the phrase "we," and he did it very effectively. So, first lesson, have credibility. You don't invent credibility at the courthouse door. A lot of people, think I can live a corrupt life and, I can cheat on my billing and those sort of things, and then all of a sudden walk into a courtroom and have credibility. Credibility is a full-time job, A. B, develop the ability to have a "we" or collective attitude with the jurors, that you can have that kind of a dialogue with them in closing an argument. And that requires some politeness. It requires respect of the witnesses you're cross-examining, respect for the court, respect for the jurors, and respect for the prosecution. And when you have that credibility, you can join forces with the jury in closing argument and ask them to do your client's bidding in the interest of justice. So I hope this has been a little helpful for you. Effective, honest, and passionate trial presentation can mean the difference between a multi-million-dollar verdict and a defense verdict. We all know that your client deserves complete justice, not that diluted version that we're always so often used to seeing in a courtroom. Don't go at this alone. When the stakes are high, you need an ally. I'm retired Judge Kenneth Adair, and I've helped many lawyers win good judgments for their clients at trial. Go to Trial.Win to learn more about my first chair, mock trial and pretrial sociometrics services to help you win your next case.